Well, good afternoon, everybody. My name is Mike Ciresi, and I didn't play in the NFL, as you can tell by my size. I did play in Division III, though. And when I started trying lawsuits about 41 years ago, I was 6'3" and I had a full head of hair.
Wow.
Now, the one thing that Ron left out, he was talking about the double chromosomes, and he talked about criminals and NFL players, I guess. He left out trial lawyers. So I want to tell you a little bit about myself. Not a lot, just a little bit. I've been practicing law for 41 years trying lawsuits. I represented the government of India in the Bhopal disaster back in 1984, and all the way up to 1998, I was trying all kinds of lawsuits, and in 98, I tried the first cigarette case in the only state that tried a cigarette case. And much of what Ron has talked about today, about the difficulty of succeeding, about the NFL isn't going to pay anymore, and they've won all the cases, etc., was true of the tobacco industry. For 40 years, they had never lost a case. And they offered us $4 billion to settle, and we turned it down. And we turned it down because they were unwilling to provide the documents which showed that they were manipulating nicotine and they were targeting kids. And we knew the documents were there. And we got those documents in our case. We tried it, and on the eve of closing argument, they paid us $6.1 billion. So the idea that cases are difficult and they have complexity is true of any major piece of litigation. It's always been true and always will be true. I want to talk a little bit about some things that Ron started out with. And he says there's, major risk that the class will get nothing. The viable damage claims are very small because each individual, each one of you, your claim in and of itself is very small. So therefore, if you had to prosecute an individual case, the cost of prosecuting that case would not warrant going forward. Well, there's some merit in that argument. But what it misses, and what I suggest, the lawyers prosecuting this case, the ones who are promoting settlement, and keep in mind the 6 original plaintiffs are not in favor of this settlement. And Fred will talk later about why he's not in favor of it. But what they haven't done, those who are promoting settlement, is look at the value. And the value is the NFL film library. So to me, I look at it and I say, all right, what do we have? The court acknowledges that you all have a right of privacy. That's a common fact, and it predominates in this litigation, which is a factor that must be looked at by the court in determining whether he will or will not certify. There's also no question that the NFL used your right of publicity. That's not even an issue. They can't realistically deny it. Oh, they can say, well, Fred Dreyer or somebody else signed one consent form for a specific purpose. I turn that around and say, that shows why they know that they didn't have it. It's an admission on the part of the NFL why they did not have authority to use your right of publicity. And secondly, the value of the library. And here's the issue, folks, that has not been constructed, the damage model. And I disagree very strongly with Ron. Lawyers sometimes do that, about how you construct a damage model, particularly in this case. What your right of privacy is worth, you can do by a number of ways. One of them is I look at the value of this asset, the NFL film library, which the NFL makes all kinds of money on. How much would the NFL sell it for? You think they'd sell it for $50 million? Do they insure it? What are the conditions of insurance for it? Would they sell it for $200 million, $1 billion? It fully supports the NFL channel. The present players, one of the buckets to fund the CBA, they get 45% of the revenues off of NFL films on a yearly basis. How much does the NFL earn on a yearly basis off of the NFL films? Now, here's the key, which I think has not been developed or articulated in this case. And by the way, there's been very little damage discovery, almost none.
Why is that?
And one of the things, because it's been held in abeyance by the court, but one of the things the court has to look at, and we can disagree with the courts, and I have a tremendous amount of respect for Judge Mangus, and I've tried cases in front of him, but I disagree with them on some things. And here, what's not been developed is the damages. Think of this. Football is a team sport. Ron talks about the star quarterback or the star receiver. Well, if Joe Montana was throwing to Jerry Rice, how does that happen? Do other receivers clean out the underlying linebackers and some of the safeties? Do the linemen block? Did the rest of the team help in preparing for the game day? It is a team sport. It's the team, all of the players who created the value in the NFL film library. It's not one individual or one star. I mean, who the hell would go watch Joe Montana throwing to Jerry Rice? That's it. Let's fill up a stadium of 60,000 people and just those two are going to be on the field. Well, that'd be interesting. It's not going to happen. So what this is a team sport, and that is how the value has been created. And that is what has not been articulated and developed in this case. So, the value of the film library, what is it? Because under this agreement, you're giving up your right of publicity. The NFL is going to have a free path going forward of any claims regarding that film library. You're giving up a constitutional right, a property right. Each and every class member is giving that up. And what the law says is you have to get a benefit, a direct benefit. What is the benefit that all of the players are getting from this settlement? And I would challenge any of you to stand up and ask Ron Mix, what specifically am I going to get for giving up my right of publicity?
What am I going to get, Ron? What am I going to get? I'm serious. What am I going to get?
Let me finish.
Well, let's wait till the end.
Yeah. Okay.
But that, and if there were a settlement that said everyone has the right to go to some insurance exchange, for example, and get coverage if you meet these criteria, that could be a direct benefit. That's not present in this settlement. There's nothing in this settlement that talks about that. It just says that they're going to give the money to this common good fund, who's then going to give the money to some third party, charitable organization, 501c3, who has requirements under the law. And by the way, the things that he put up on the board, the elements, and we can go through it, it's in the settlement, it says for retired players or other similarly situated people. Well, who are they? Does it cover me as a Division III old warhorse retired football player because I got bad knees? Can I go in and say, I'm a similarly situated person? I played football. I got injuries, and I've got uninsured expenses. What does that mean? Can any of you go in and say, because of this, I get this benefit? No, you can't. So there isn't any direct payment, and that's one of the issues that the court is going to have to face. Now, what's the NFL getting? They're getting this film library, and they're going to continue on in perpetuity, or forever long we're here on this planet, of making money off it, year after year after year. What else is certain about the settlement? Well, one thing that's certain is that the attorney's fees are going to be paid after final approval, if the court gives final approval. And they don't wait for 8 years to get their money. Now look, I'm a lawyer. I think lawyers are entitled to fees if they do what they're supposed to do. But if the players have to wait for 8 years, why did the lawyers get it all? their payment up front. I don't understand that. $50,000 is going to go to set up this licensing agency. Well, that's wonderful. What are you going to get for $50,000? He's going to have a full-time executive director? You think you're going to get a full-time executive director for a license agency for $50,000? What about health insurance for all that? What about the lawyer's fees, the accounting fees, the space, and I can go on and on and on. So $50,000 to set up this license agency, which I hope we're going to talk about. Because the question is, what are you licensing? I'd like to go through just some of the provisions. First of all, by the way, he talks about the fact that, gee, I don't think this is a very good case. This is sort of curious to me. Lawyers start a lawsuit, and they have to say that they have a viable cause of action. I mean, it's required, ethically, to bring the cause of action. And then all of a sudden they get to a point where they want to settle, and they say, I'm sorry, we've got a shitty case. Okay? Well, one of the things in the settlement agreement, they actually say this. It's in the whereas clause. They continue to believe that their position has not some merit, or a little bit of merit, or a modicum amount of merit, substantial merit. That's what these settling lawyers are saying, that our position has substantial merit. Well, if it does, on one hand, are you saying the truth there? Or are you now saying you don't have a good case because there's certain cases out there that say we may not be able to recover, such as the Gianfrido case? Well, this court, Judge Magnuson, on Gianfrido, distinguished it from the facts of this case. Because he said in that case, everything there was publicly available. They were talking about statistics, etc. And he went on through a very detailed explanation of why it's distinguished. Is he going to now reverse his position and say that it's not distinguishable? I don't think so. I don't think so. Now, he may not certify for other reasons, and that is a risk. But I ask this question. If there's a risk and the class gets nothing going forward, what are they getting now?
Nothing.
And if they're getting nothing now, it seems to me I'd rather go down on the field of battle
Yes, me too.
than sit back and say, maybe I'll get something. And that's the issue here. What are the players going to get? And yes, you want to take care of those who are worst off. There's no question about that. But this settlement agreement, in our opinion, does not do that. They say that players signed consent to use images. Yes, but only, as I said, for specific instances. They say the NFL player contract didn't grant residuals or royalties. Yes, it didn't, but it said only while playing. That's why today's collective bargaining agreement, the one most recently negotiated, specifically gives up this right. Now, one can argue that that's, again, is an admission that it wasn't given up before. It's a question of fact. And questions of fact are for a jury. They're not for a judge to decide. He can decide legal issues, but questions of fact are for the jury. You know, some of the things in here, you know, and we'll go through it, but one of the things that they say, we're going to help you promote. You know what we're going to do? We're going to have 100 jerseys, up to 100, or a minimum of 100 jerseys of retired players in our places. 100 players. Well, I did a little calculation. 100 players of 17,000 is 0.006 of 1%. What in God's name is that going to do? How's that going to help anybody? Let's talk about the agreement. The payment. Payment, as Ron pointed out, is $50 million. Now, $7.5 million goes towards attorney's fees. paid after final approval. $450,400 goes to the administration of the settlement itself, and another $50,000 to set up the licensing agency. Now, at the preliminary approval hearing, the NFL stood up, the NFL, not the NFL, it was the settling lawyers representing the class, and said the NFL had told them they'd also pay right away $50,000 to set up the common good entity. So I guess it's another $50,000. In any event, it leaves $42 million paid over 8 years, $5 million in each of the first 3 years, $4.5 in years 3 through 8, subject to this clawback of $13.5 million. And by the way, the $13.5 million there will be opt-outs, Mr. Mix. That I can tell you. I would fall over if there weren't any opt-outs, because I just know people are going to look at this and opt out. And the $13.5 million, which can be drawn down in years 6, 7, and 8, so maybe no payments in 6, 7, and 8, is not just for settlement of opt-outs or judgments on opt-outs, it's also for attorney's fees. Do you know that the NFL employs lawyers from Wall Street? You know how much they charge? A lot of money. That $13.5 million is going to get eaten up pretty quick. So let's say that it's going to be 28.5. Just let's say it is. But again, it's going to be paid over a period of years. So if you discount it at a 5% discount rate, the present value of that is about $25.4 million. You got to look at the present value of money. And if all the money isn't spent 2 years after the settlement is done, it reverts back to the NFL. So they can then spend it as they see fit for the common good of the retired players. So that's the payment part. The release. The release at page 22 of the settlement agreement provides for past release and future release. And the past release is for all claims of your publicity rights. And that's the right to exploit a player's identity elements. And identity elements are defined in the agreement at page 14, which includes your name, your nickname, your initials, your likeness, your image, photograph, animation, person's autograph, signature, appearance, voice, personal or biographical data, or any other identifying or personal characteristic. I suppose if you had a kid named Shorty, and everybody knew that Shorty was your son, that would be part of it. I don't know. Because I don't know what other identifying or personal characteristics are. I know that that's fraught with an ability to get involved in litigation over it. And then at page 23, it goes through the future release in perpetuity. And there you give up all publicity rights that publicize, promote, market, or advertise the NFL, member clubs, the sport of the NFL football, or any NFL game, or anybody that they license to do that. And then it's got A through E subparts that explain everything that they can do. Now, there's an endorsement exception. You know, Ron, I'd like to ask you what the heck this means. It's on page 23. We should maybe, we probably can't get into the nuts and bolts. We don't have time today. But they got an endorsement exception. And what it says is the release that you're giving doesn't include any use of publicity rights in a manner that constitutes an endorsement by a class member of any non-NFL party, brand, product, or service. An NFL party is described as all the clubs in the NFL, etc., okay? Provided further that the use by a non-party of NFL game footage, including in advertising and promotional material that is authorized by an NFL party, in other words, one of their licensees, and that does not unduly focus on, feature, or highlight an NFL player in a manner that leads the reasonable consumer to believe that the NFL player is a spokesperson for or promoter of the non-NFL brand, product, or service is not an endorsement. So, you might say, well, how do we know whether it's an endorsement or not in the eyes of a reasonable consumer? Well, you'd have to litigate to figure that out. And if you litigate under Section 3, Roman numeral 3D, and you lose, you have to pay the NFL's attorney's fees. Now, I don't know what happened during the negotiations. We just got hired 3 months ago. But it would seem to me that if they were going to argue about, well, you know, you're going to pay our attorney's fees, and I'd say, well, okay, then if we win, you should pay our attorney's fees. Not in there. That's not in there. That's called mutuality of obligation. Then there's a covenant. You not only give releases, you covenant not to sue them. And these are two key provisions. You won't contest the exclusive right of the NFL to NFL game footage or produce, license, offer for sale, sell, market, or otherwise distributing NFL game footage. In other words, they retain the exclusive right, and this is really important for the licensing agency. Because even if you have one of these group publicity rights, and we're going to get into that. These are really fun things. First of all, they got one if you got 6 players, and then they got one if it's, or 6 or more, and then they have one if there's 50, and all the exceptions that go with it. You look at this, and you say, all right, well, gee, we can do this. Well, not so fast. Because what you have to do, because they have the exclusive right to all this, you got to go back. Let's say you line up a sponsor or something to do this. Well, that person's got to go back to the NFL and get a license from them because they got the exclusive right to license. And on their IP rights, they say the NFL has the sole right to license the NFL intellectual property rights. The licensing agency, this is the one created this great benefit thing, has no authority to license the intellectual property rights of the NFL. So no matter what deal you do, if you could do a deal, you got to go back to the NFL. And if you go back to the NFL, they're going to consider a request, and they got 10 days to consider it, as to whether they're going to withhold consent. And in deciding whether to grant the requested license to whatever deal you put together, the NFL will apply in good faith the same standards that it ordinarily employs in deciding whether to grant licenses for that type of NFL IP rights. Well, what are those? They're not spelled out. And is the NFL going to allow you to compete with what they're licensing? And moreover, and this is just a matter of opinion on my part, there's different ways you construct damage models. And sometimes you have to be creative in doing it, working within the law. And my objection to this is that that part of it has not been done yet. So the court may approve it, the settlement. And one of the reasons, and I said this in open court, so I'm not saying anything I didn't say to the court, is that the magistrate who works with this judge was actively involved in supervising and participating in the settlement discussions. And sometimes when that happens, the person takes a little bit of ownership because he or she believes it really is a good result and they want to get it done. That's just human nature. I'm not criticizing the magistrate for that or anything else, but that is a factor here. But I don't think either the magistrate nor the court have had a full exposition of the damage model put forth so that they can make that determination, which a judge has to make. Is it fair for all the class? Because each one of you who agrees to this is giving up a constitutional right, a property right. And Ron Mix nor anybody else. And I wish, Mr. Gustafson couldn't make it. I wish that Mr. Hausfeld could have come. I don't know, maybe he's got something better to do. Or how about Mr. Zimmerman? They're the ones promoting this. I wish one of them would have been here. But I dare say that none of them can say specifically, if I give up my right, who am I going to apply to and what will I get? What are the criteria to get these medical benefits or housing or whatever it is? And is that criteria applied across the board so that I know that when I go in, I will get it? That has not been articulated. So I do not believe under the law that they have shown a benefit. Now the court in the preliminary approval disagreed with me, so you need to know that. Says, well, this really isn't what we call a side prey. That's an award for third parties, because there is a benefit. Well, I'm still sort of stymied as to what the benefit is, because I don't think anybody can articulate it, other than maybe when this is set up, maybe you can go and you may qualify under whatever is set up. But, just being a young Sicilian, I was taught, don't buy a pig in a poke. I don't know what I'm getting here. I don't know when I go in what I'm going to get back. So I think we ought to talk about the provisions and see if Ron can answer, because I got a couple of questions for him. I just don't understand it. Maybe you do, Ron, although you said you weren't involved in negotiating it. But there's things I'd like to know so the players would know whether they should support this or not support it. Thank you very much.
Boom 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 boom